Hello, visionaries. Welcome, welcome, welcome to the first live stream of Talbert Law Office. My name is Maresa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go to legal resource for all things business, nonprofit, and intellectual property law. And I don't know how many people are on this live stream right now, but this is something that we received some interest from on our YouTube channel at Talbert Law Office. And this is something that we plan to incorporate more in the future so that I can answer your questions in real time. So I see that we have somebody who has already put a question in the comments about, do I take clients from Las Vegas? It depends. So there are a number of things that I can do for people in Las Vegas. Those are I can work on contracts for based in Las Vegas or based on Las Vegas law. And I can also work on intellectual property matters such as copyrights or trademark registrations, the enforcement of copyrights or trademark registrations in any state. So I hope that answers your question. Are there any other questions? Okay, so need help in structuring businesses under your parent company. So I would like to give an overall description of what that means and talking about structuring the businesses. So there is a difference between a holding company, which many people have heard about, and a parent company. Sometimes people use those terms interchangeably. I like to say that a holding company is a company that owns part or all of a company or multiple companies, but does not transact business on its own. So it does not operate other than to own a company or part of a company. A parent company is a company that owns part or all of other companies, but it also does its own transacting of business. An example of a parent company is like Amazon. Amazon has its own operations, but it also owns other companies like Whole Foods and things like that. So that's a parent company. A holding company would be the company that owns Google. Nobody knows who they are. But they own the Google company, and then the Google is the subsidiary company that transacts all the business. So that's one distinction that I would like to make between parent companies and holding companies, even though people use those interchangeably. So then structuring a business under either a parent or a holding company, it depends on what business you want to structure. Typically, if you're structuring a subsidiary company under some type of other company, you're more than likely going to be choosing between two types of business entities. Normally, that's going to be either an LLC, a limited liability company, or a corporation. It could be an S corporation or a C corporation. So, when you are thinking about how to structure your businesses, I'll talk about the LLC first. Generally, with an LLC, obviously, you're going to have to file some type of documents with your Secretary of State um, that will start the actual company. The other thing that you want to make sure that you have, particularly with an LLC, is an operating agreement. Operating agreements are important whether you are the only member or whether you go into partnership and have other members, whether you are a member and you also have a manager who manages most of the things. Either way, you want to have either a single member operating agreement or a multi member operating agreement, depending on which one fits your model. The other thing that you want to think about with an LLC is making sure that um, you understand that you cannot commingle personal funds and business funds. So with an LLC, you need to make sure that you have business bank accounts set up to operate that LLC. The other thing that you want to think about with an LLC is ensuring that you are, if you have a business name, making sure that you understand that your LLC does not protect your business name. So that's one myth that I hear a lot, that people tend to think that just because they have an LLC and that their LLC was granted with their Secretary of State, that it protects their business name. It does not. If you want to protect your business name, then you want to think about or consider getting a trademark for that business name. So that's something else I can talk about. But those are the main things that you want to make sure of when you're thinking about how to structure your LLC. On the other hand, you may want to structure a corporation. Corporations, the big thing about corporations is that they are an entity that has stocks, and stocks are considered securities under the law. So I have a video on securities and what that means, understanding stocks 101. But generally, you want to make sure that you understand what that means. So a stock is basically in exchange for a percentage of ownership, depending on how many stocks that your corporation has. So your corporation can have 100 stocks, it can have 100,000 stocks. But what that essentially means is whoever owns a stock or stocks in your company also owns ownership. The good thing about that is with a corporation, there are different types of classes of stock that you can issue in a corporation. And that allows investors, that's why investors like they like corporations, because you can dole out those different types of stock. So that comes in handy when you may want to have owners in your company, but you may not want them to make decisions. Or you may bring on an investor and they're going to be a silent investor because they're just giving money and they're not going to have any dealings with the day-to-day activities of the business. The other big important thing to know, similar to the LLC, you will still file some type of document with your Secretary of State to start your corporation. You want to have what's called a shareholders agreement, which is similar to the operating agreement for an LLC. You'll have a shareholders agreement with the corporation. The other thing that's important to have in a corporation are bylaws. Bylaws are the governing documents of the corporation. And when you have a question about, can I do this? Can I do that in my corporation? Then you refer back to your bylaws. So those are some of the main parts of either one of those types of business entities that are generally going to be the subsidiaries of either a parent or a holding company. So I hope that answers or gives you some insight on your question about structuring businesses under the parent company. Okay, so another question. What is one of the main guidelines you advise in starting a nonprofit? So one of the biggest misconceptions about a nonprofit is that it has no laws. A nonprofit organization is one of the most regulated business entities that has ever existed. They are more regulated than a for-profit company because the law considers a not-for-profit owned by the public. And because a not-for-profit generally is going to receive public donations, public money, either from the government by way of government grants, or just by public donations, because people like to donate to nonprofits and then use that as a tax write-off. The law says that this is owned by the public, and so we have to be very cautious about making sure that people don't abuse the nonprofit privilege of being a tax-exempt entity. So one of the things that I like to advise with a nonprofit is understanding the laws of your state. So in some states, there are generally 2 to 3, maybe even sometimes 4 different entities that you will interact with as a nonprofit. One is going to be your Secretary of State, which is going to handle any business in any state. And a nonprofit organization is a business. In most cases, it is considered a corporation. It is just a not-for-profit corporation. So that starts off again with your Secretary of State. The other entity that any nonprofit organization will engage with is the IRS, the Internal Revenue Service. The nonprofit structure is based in the Internal Revenue Code. So it is a entity that is designed strictly by the IRS. And basically what a nonprofit is saying is, hey, I'm a business. I'm doing such great work that benefits the community. I'm taking a load off the government because of the type of work that I do. They don't have to worry about doing that. And for that reason, I should be exempt from paying taxes because I'm doing a service for the government, basically. That's what a nonprofit is. And so you're telling the IRS, hey, I'm doing such good work. I'm helping youth get scholarships, or I'm helping disadvantaged people, get food or get legal services, or whatever the mission is of the nonprofit. And so when you hear these different like 501c3 terms, or 501c6 or 501c27, that is the code section of the Internal Revenue Code, of the tax code. So again, a nonprofit will engage with the IRS. Another entity that the nonprofit will engage with in most instances is the state tax entity, for whatever state, wherever the state is, whatever state the nonprofit is formed in. In California, it's the California Franchise Tax Board. In Virginia, it'll be the Virginia Division of Taxes. So in any state, your tax entity will also be a part of that nonprofit organization. Some states, once you are tax exempt from the federal government, from the IRS, they will automatically make you tax exempt within the state that your nonprofit is based in. Some states do not do that. You have to then apply to also be exempt from state taxes. And that's one thing that a lot of people forget to do, because they get their letter from the IRS saying that they're a nonprofit. They forget that maybe their state has not made them exempt from state taxes yet. And then the other entity that a nonprofit may engage with is the Attorney General's office of that state. And sometimes there's a registry with the Attorney General's office in that state that every charity or every tax exempt entity will have to register with to become a nonprofit. So that is kind of the overall general setup. The other thing is making sure that you understand what you're allowed to do and not allowed to do as a nonprofit. I work with a lot of nonprofits, and most of the time, they don't understand that they are the most regulated entity. They don't understand what the perimeters are for hiring, for giving out stipends to volunteers. They don't understand even what their tax exempt purpose really means or is. And those are all things that you should become intimately familiar with if you're looking to start a nonprofit, or if you're working within a nonprofit or volunteering with a nonprofit. Those are some of the things that you should be aware of. Okay, I see another question. Just curious about your company and any offerings you may have. I have a trademark registered but not conducting business now. How long is a trademark still good? Okay, that's a great question. So my company, Talbert Law Office, we handle business transactions, formations, business entity formations. We handle contracts, drafting, both drafting contracts and reviewing contracts. We also help to negotiate contracts and business deals. We handle nonprofit formations and everything in between with a nonprofit. We also handle trademarks and copyright, both registrations, maintenance, and enforcement of your intellectual property rights. When it comes to a trademark, so a trademark is one of those intellectual property, one of those types of intellectual property that can last forever. However, there's a caveat with that. One, there is maintenance that is due. When you first receive your trademark registration, you have to renew it between the 5th and the 6th year that it's been registered. So let's say you got a trademark registered in 2020, you would be scheduled to renew it in 2025, between 2025 and 2026 of the month that your registration was granted. So if you received your registration July 20th of 2020, your first renewal would be July 20th, between July 20th, 2025 and July 20th, 2026. And then every 10 years after that, so July 2036, July 2046, every 10 years after that, you'd have to renew as well. Now, the thing with that is a trademark can last forever as long as it is in use. So when you are renewing those trademarks, when those trademark deadlines come up to renew, what you are saying to the US Patent and Trademark Office is, hey, I'm still using this mark. And so if you have a trademark that's registered and you're not conducting business right now and you're not actually using the mark, you generally have until your next renewal comes up to then start back using that mark. Because when your renewal comes up, they're going to ask you to show proof of how you're using the mark. And if you cannot show proof, they're going to deny it, and your trademark will then go dead and be considered abandoned. And you won't have a registration anymore. The other way that you can lose your trademark registration is if someone else is applying for a trademark similar to yours and their trademark gets denied because your trademark exists, and they go and do research and say he's not even using his trademark anymore, I'm going to file a petition to cancel this trademark because they're not even using it, which I've done before. So it does happen. That is another way that you can lose your trademark before that renewal period comes up. But generally, in most cases, you can wait till the renewal time. And by then, you need to be using your trademark again, because like I said, they will ask you how you're using your trademark. And if you can't show proof on how you're using that, then you'll lose it. Great question. What are the most common mistakes entrepreneurs make when protecting the intellectual property of their businesses or products, and how can they avoid them from the start? I love this question. So, general mistakes that entrepreneurs make is using a mark before they start protecting it. Now, that's not always a bad thing, because with trademarks, again, like I said, if you're getting a trademark, they're basing your trademark approval on the use of the trademark. I like to tell people there's two types of trademarks. There is a trademark application that says, hey, I'm already using this mark out in commerce. People know me for this mark. I'm already using it. Go ahead and grant me the protection. And there's another trademark application that says, I'm kind of scared to use this mark before I protect it. I don't want anybody to steal it, so I haven't really started using it. But as soon as you approve my trademark registration, I'm going to start using it immediately. That's called an intent to use. So there's an in use, which like I said, I'm already using this. People know me for it. And then there's an intent to use. I'm not using this because I'm a little scared that somebody's going to steal it from me. But as soon as you grant me protection, I'll start using it. So I say all that to say, sometimes it's not always bad to start using your mark before you start applying for the registration. But in most cases, people are doing those things almost at the same time, where they're applying for the application. So their application is pending and they're starting to use the mark. But what happens more often than that is people go out, they spend money on their brand, they spend money on whatever they think their business name is, or their logo or something like that. And then they either get a cease and desist letter from another trademark owner saying, hey, your trademark is way too close to mine. Stop using it right now. I'm going to take every dollar that you've made off of this brand, and you cannot use this anymore. That happens often. Or you'll get sometimes somebody has spent a lot of money on a brand, and then we go to do a trademark search to see if it's available for them to protect, and it's taken. It is completely taken. and they can no longer use that trademark. And they've spent all this money, they've advertised, they've done all these things, and they can't even use their mark. So that's one big thing that I see way too often. And I hate when it happens because people are so invested when they think they've come up with the most creative name and then they find out it's already taken. Which is why at Talbert Law Office, any trademark that we do, we're always going to do a trademark search and we're going to come back and let you know, okay, we think this is good to go based on this. This is what we found, or this is off limits. This is what we found. So a trademark search is it's non-negotiable. You should always do a trademark search. The other thing that I see a lot of entrepreneurs do is they share their ideas with people before they've done anything about protecting it. And then they come, they might be slow rolling on getting the ball rolling, or they might be waiting to get money together, or whatever the reason is. But then they find out that the person they shared information with has now taken it and used it. Or they might share some snippet of it, or they might say a business name, or say, I have this idea to do this on social media or something. And the person who has the money to implement that immediately does, and their idea is gone. It's taken because they shared it before they went through with trying to get it protected, or sharing it with maybe someone who was going to help them. I've seen it happen with people who were building apps, like phone apps or computer apps. They share it with like somebody who's like an engineer without a non-disclosure agreement. And then that person goes and kind of takes the intricacies of that idea, takes it, runs with it, and they can't do anything about it. So those are the main things that I have seen with my clientele when it comes to mistakes with intellectual property. It's either sharing it too early without protection, without any contracts in place, starting and building out a brand when you haven't protected it and somebody else already owns it, or not protecting it at all until it's too late, or then you're just running with a brand and then you get either a lawsuit or cease and desist letter or something to that effect. Okay. Does the company have to be governed by the government if it's a nonprofit? Um, I'm not exactly sure what you mean by that question, but I will answer what I think the question is asking. So a nonprofit, so any business entity is going to have some level of governance by the government. A nonprofit generally in many cases is going to be run by whoever started it. So I have a nonprofit that I started, and so the people who I myself, my co-chair, and other volunteers and the people who we hired, we run the day-to-day of that nonprofit organization. And so just like a business, it's going to be based on who you hire, or who you bring into that business. The nonprofit is the same way. As far as who's running the day to day. But when it comes to the structuring and the legalities, obviously that's going to be based on government and the laws of the state as well as the federal government. I hope that answers the question. I think that was the question that was being asked. Okay. In order to work with you, do we come to your office? Second, how are you hired to help with more than one business? This is all new to me. Forgive my ignorance. No, these are great questions. Thank you for asking. Okay, so in order to work with me, no, you do not have to come to my office in person. I do virtual consultations all the time. And I work with people across the country in multiple states. And so I can do everything virtually, generally speaking, unless I'm in a lawsuit where then I have to show up in court at the courthouse. Everything else that we offer can be done virtually, and we can set up as many virtual consultations via Zoom or Microsoft Teams, whatever, by phone, to get those things done. And That is probably 90% of my clientele. We handle things virtually. Um, so that there's no problem there. Second, what was the second question? How are you hired to help with more than one business? Okay, uh, so for I'll answer this in kind of multiple parts. Um, so I'll talk about first fees, right? Because that's part of the hiring process. So generally, when someone is interested in working with Talbert Law Office, we schedule a consultation. During that consultation, it's a 1 hour consultation. We talk about the goals of the business, the entity, the person, creators, nonprofits. We talk about the goals, the objectives. What do you need? What are your concerns? What do you feel like you're missing? And then we put together based on what you tell me, then I can tell you, oh, if you want to protect this, then you're going to need a trademark for that. This may be the best option for this. This may be the best option for that. Like, I'm going to give you some information that you can take and start with that same day. And then I'm going to give you some legal services that we offer that you may want to consider. So that's kind of the consultation. And then working with us, if you hire us for, representation in any way, we offer flat fees. So I will talk generally about how many law firms work. In many law firms, when you hire the attorney, you are hiring them on an hourly basis. So they are charging you based on the number of hours that they spend on your matter, and that's going to be based on their hourly rate. So their hourly rate is $400 an hour. They're going to charge you for 2 hours of work. They're going to charge you $800. And the disadvantage to that is that you can be left with surprise bills if you were expecting that they were going to form a business for you, and then you get this bill at the end of the month that's well over your budget of what you expected to pay because you didn't know that it was going to take them that long to do whatever it is that they're doing for you. On the other hand, at Talbert Law Office, we offer flat fee services. So we offer packages. So you know upfront what's coming in your package. We're going to give you everything that you need, and this is the price, whether we spend 10 hours on it or 2 hours on it, and we're going to carry you all the way through that process. And you are our client until that process is complete. And so that is what we call like limited scope. We're doing one or two things for you. We're setting up the business and we're doing the trademark. Then there's the other type of model that we have where we do subscription billing, which is where you can pay us a monthly fee and we're on call for you. So basically we are your kind of in-house attorney. And that works with some of our other clients and businesses where they know they're coming to us. If anything is happening, they're calling their lawyer, which is our office. And they kind of have us on standby to be available for whatever's happening. This contract, we need this reviewed. We have this going on. Can you show up to this? We want that. We're planning to do this. We're thinking about this program. What do you think about it? So those are the main two types of billing that we do with our hiring. Flat fee services. So you know upfront what you're paying for and there's no surprises in your billing. And we also have monthly subscriptions where you have us kind of on call as your legal bestie, I like to say, to handle everything that comes up in your business or your nonprofit. Okay, I'm about to expand my business internationally. What steps should be taken to ensure intellectual property is protected in different countries? Great question. If you have a trademark, I'll start there. If you have a trademark registration already in the United States, then what a lot of people do is they go ahead and they apply for what's called the Madrid Protocol application. And that application applies to at least 66 different countries abroad. And so by filing that application, then you can get your trademark registration. Once it goes through the process, then you can get your trademark registration um, registered in those countries in one application, as opposed to multiple separate applications with each different countries with the WIPO office, which is the World Intellectual Property Organization. But you'd have to do that with each separate individual company or country internationally. The Madrid Protocol kind of streamlines that and makes that a much easier process. And that can be done through the US Patent and Trademark Office. So that's one thing, one nugget that I'll give. The other one is if you have any copyrights. Generally, in many countries, the copyright laws mirror the United States copyright laws. So you would there is no joint kind of copyright application. But if you know the particular countries that you will be kind of operating in, if you have some copyrighted material, then you can either go through those through those individual countries. But in many cases, there is reciprocity between some countries internationally and the United States. So that's something to look into to see where you'll be operating and to see if that country has reciprocity with our US Copyright Office. So those are two big nuggets that I think will be really helpful if your business is going to be expanding internationally with regard to IP. Okay, Oceans, Light Warrior. I'll I'm going to put by the end of this, I'll put my email in the chat, and then please contact me, and we can talk about maybe how to get you set up for having a regular attorney on call. Do you work with real estate and contracts concerning commercial real estate? Yes, I do. I have in the past. If there is something that I feel is outside of my expertise, I do have very close relationships with real estate attorneys as well that I can bring in. But yes, I have worked on real estate contracts and commercial real estate. Um, so I'm generally comfortable with those contracts. I've seen a lot of them. How can I protect my idea when sharing it with an investor if I haven't started the business yet? Great question. Okay, so if you have not started a business yet and you need to protect an idea, that's where contracts come into place. And I love talking about contracts. It is one of the biggest, most useful tools in the law that has ever existed. And so, the kind of contract that you would need if you needed to protect an idea while sharing it with an investor is a confidentiality or a non disclosure agreement. That is the contract that you will want to have when you are sharing your ideas with anyone before it's actually materialized. So, what a confidentiality agreement basically is saying is that I'm sharing something that is worth protecting with you, and you are going to agree that you're going to keep this confidential and that you're not going to try to compete against me and as I'm sharing this with you. And that if you do that, then you basically have to pay me for it. And in some instances, it's so egregious and it's such an awful tactic that there's not enough money in the world that you can pay me. So, I may need to, you can put different things in your contract, but generally that's what a confidentiality or a non-disclosure agreement is saying, is that there's not enough money in the world for you to pay me if you spill this secret, and so you have to keep it confidential, and if you don't, then there's going to be a lot of money to pay. We have those in our TLO marketplace. If you go to www.talbertlawoffice.com /TLO-marketplace, you can grab a non-disclosure agreement, and you can get that right now. It's in an immediate download that you can purchase, and have that at your fingertips if you need it. Any other questions? I don't see any questions right now. So I will generally just kind of um, do a kind of wrap up of generally the topics that we cover. Um, so we kind of talked about the LLC and the corporation. Oh, please, if you have more questions, keep them coming. We still have 20 more minutes left in this live chat, or live stream. So if you have more questions, please feel free. Um, but in the meantime, if there are no more questions, I'll just kind of do a general wrap up. So we talked about the LLC and the corporate business entities. I just want to point out there are other business entities outside of that. There's also a partnership. Those have its own pros and cons. But generally, most people hear about the LLC and the corporation. The distinction that I want to make it between the corporations is that there is an S corporation and a C corporation. And so when you're talking about a C corporation, those are corporations that have different classes of stock. And those are the corporations that investors really gravitate to. So if you're looking to do some type of investor funding, you will want to go with a C corporation. It is inherently built to accommodate having an investor that cannot take over your business. And so the C corporation is the way to go. Investors love it because there's no liability on them. Even if they give you money toward your business, they're not held responsible for the activities of your business, and they just want to get paid back. They don't like the LLC structure that much because the LL the default of an LLC is that every person who is engaged in the LLC has voting rights. They have equal rights across the board. They have equal losses and equal access to the losses and the profits of the company, and investors don't like that. So they generally stay away from LLCs. The other type of corporation is the S corporation. With an S corporation, there are some limitations. A lot of people like this because um, it's easier on the taxes than a C corporation. With a C corporation, both the employee of the corporation is taxed and the business is taxed. With an S corporation, the business itself is not taxed, only the employee of the corporation is taxed. So if you hear double taxation versus single taxation with a corporation, that's what it's talking about. A C corporation is double taxed, an S corporation is not. It's called pass-through taxation, which means that taxes come through the shareholders, or the people who own the corporation. I see. I see another question. What if I start a business like an LLC but need to change it later? Can that be done? Yes, great question. Yes, an LLC can be converted into either an S corporation or a C corporation. An S corporation can be converted into a C corporation. So yes, you can definitely convert an LLC into a different type of business entity if you want. And people do it all the time. It's not hard to do, and that can be done very easily. And I'll keep talking about the S corporation a little bit more, just to just make sure that you understand. With an S corporation, it is limited to 100 owners, whereas a C corporation has unlimited, which is why some companies go public. Um, and an S corporation, it has its benefits as far as the taxation, But the one thing that you need to do in order to get that benefit is that you have to be an employee of the company, which means that you have to be paying yourself on a regular basis what the IRS calls a reasonable salary. And you need to be a W 2, Form W 2 employee, the same way that you would be an employee if you went to go work for someone else. So that's the big thing with an S corporation is making sure that you are an employee of the company. That's really the only way that you get the benefit of the S corporation. Can you run more than one business as the CEO? Yes, you definitely can. There is no limit to for-profit businesses. You can have as many for-profit businesses as you can maintain, and you can be the CEO of all of them. There is no limit legally. There is no limit to being the CEO of more than one business. Big businesses and people do it all the time. And as long as you can manage that practically, you're good to go. Okay, I see another one. You mentioned the Madrid Protocol, but how does that work when trying to bring a trademark that's already registered in another country into the US? Are there specific challenges or steps? No, generally, if you are bringing in a trademark that's already registered in another country, you're just going to go through the US Patent and Trademark Office process, just like any other US trademark. So there's no challenges, no steps that are different than any other type of US trademark. The process will be exactly the same. These are great questions. So I won't be putting the business up for any stockholders. Can the business be a C corp or is it better to be an LLC? So if you don't plan on having any investors, then it is probably going to be better to have an LLC. A corporation has what's called corporate formalities, which again, I mentioned bylaws, I mentioned shareholders agreements. A C corporation requires you to have meeting minutes. It requires you to have an annual meeting. There's just general things that are corporate formalities that are required to happen in a corporation. And if you're running a business by yourself, you generally don't want to have to do any extra steps. So if you're running the business alone, an LLC is going to be much more easier to maintain. It's going to be much more easier to run and to manage. And it's going to be much cheaper in most cases on your taxes and on your annual maintenance of filings and your general day-to-day operations. So there's much more flexibility with an LLC than a C corp. So an LLC is probably going to be the better way to go in most cases. Now, like I said, that doesn't always apply because for some people, a C corporation, just for the longevity of what they want to do, is going to be the better option. But 90% of the time, an LLC is going to be much easier and the much better option. Can holding companies conduct business or not? Holding companies can conduct business, but that takes them out of being a holding company into being a parent company. So nothing says that a holding company cannot conduct or transact business. It just then they would be called a parent company because holding companies are reserved, the title holding companies are reserved for those companies who do not transact business. But if you set up the company itself, it's not going to there's not a different setup for a parent company. It's just the nomenclature. So yes, a holding company can conduct business, but then it'll just be called a parent company. I tried selling corner clocks with a coating. The exclusivity is that the hands must be removed by turning the mechanism along an axis located perpendicular to three dimensions. Is there a question? I'm not sure if there's also a question. that accompanies that last comment? If so, I'll continue to look out for it. In the meantime, I will kind of talk about the trademark process. We got quite a few questions about trademarks this evening. So I will generally explain the trademark process because a lot of people don't know it. So your trademarks will go through the US Patent and Trademark Office for US trademarks. The US trademarks will approve trademark registrations that protect your trademark nationwide. There are also state trademarks that generally go through the Secretary of State's office within that state. I generally do not like state trademarks because they only protect your trademark in that particular state, and sometimes not even the entire state. Sometimes it's just a certain region of the state, depending on if there's another business name or another trademark that is similar in that same state. So when you are looking to protect a business name, a logo, trademarks also protect a look and feel of a place, such as the Chipotle industrial restaurant feel. That's a trademark. Trademarks can protect sounds, such as the ESPN sound or the NBC sound. Trademarks can also protect colors, such as the UPS brown or the Tiffany's blue. So trademarks can protect a lot of different things other than just a business name or a logo. It can also protect slogans. And so when you're looking to do that, you want to really be looking for the federal trademark that's going to protect your trademark nationwide across all states. The process right now is generally it takes about 18 to 24 months, almost 2 years, to endure the entire trademark process. When you apply for your trademark, generally it's going to sit in a queue until it gets assigned to a trademark examiner, and that takes about 6 to 9 months by itself. I know, appalling. It's bad, but that's just the reality of it. And then once it's assigned to that trademark examiner, they will review your application. They will process it. If there's any questions, if they need additional information, then they will reach out and say, hey, it's missing this, or hey, we need more information about this, or hey, we don't think we're going to approve this because this is the law says this and this it's a little too similar to this trademark and we're just not sure about it. You get two chances to argue back and say, well, you should approve it because of this and this and this, and it's not actually similar to this because they're doing something totally different. And so once it goes through that process, then on the other side, then you may get your trademark registration, and sometimes they still continue to refuse it. So the trademark process is not a guarantee that you will get an approved registration. Um, but that's where the trademark search comes in making sure that you present the most robust and the most accurate application possible, and that you can see and kind of identify any issues that may arise before you move forward with an application. Um, as I mentioned, there's two types of trademark applications. It's the intent to use, which is like, I'm waiting because I don't want anyone to steal it. And the end use, which is saying, I'm using it already. Let's get this protected. The other thing is, although the trademark process takes about 2 years, um, when you get the registration, the certificate, it will start your protection on the day that you actually filed the application. So it doesn't start it. You get that entire time that it was processing, you get that time of protection as well. So it's retroactive to when you filed it, not when you received your registration. Um, okay. Can you, Evgeny, I'm not sure if I'm pronouncing your name correctly. Can you put I think it cut off just because of the characters. Can you put your question, the second part of your statement and your question back in the chat again? And I'm happy to answer that. Trademarks are for name and logos, right? Trademarks are for names, logos, slogans, colors, sounds, and what's called a trade dress, which is the look and feel of something. So the Coca-Cola shape, the bottle, the Coca-Cola bottle shape, that's protected. Um, like I mentioned, the UPS brown color, that's a protected trademark. The ESPN little sound, that's protected by trademark. Chipotle, if you've ever been in a Chipotle restaurant, that industrial look that they have, that is protected by trademark. And then, yes, business names and logos, definitely. But trademarks are much more expansive than just business names and logos. They protect a lot more. So we've got a couple of minutes left, and I'm gonna wait for this last question to come in from Evgeny. While we wait for that question, I just want to thank you all for coming. Thank you for such thoughtful, wonderful questions. We will continue to do these lives. We're going to do another one next month. We'll keep this going. Continue to bring your questions. I love having this moment to interact with you in real time and to really answer the questions that you need specifically answered. And if you have topics that you want me to talk about on YouTube, please, if you haven't already, subscribe to the Talbert Law Office YouTube channel. Check us out at talbertlawoffice.com. Check out our marketplace if you need contracts. We have 15 different contract templates. They come with a user guide. So we are telling you exactly what each provision in the contract means. We're telling you how you can change it up and what that means. And these are contracts that you can use over and over and over again for your specific business transactions and needs. And so thank you again so much for joining us this evening. And I look forward to chatting with you again. I appreciate you all for being here. As always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I will see you in the next live chat. Thank you.